I should look kind of normal, right? I have to be on a video. Recording in progress.
You see with everybody right now. So I had a conversation, you're muted, right?
I'm trying to figure out how to make someone a co-host in case I need to.
All right, so co-host is going to be,
Hold on. Let me.
Hey, Owsley, it's Ellie. Do you need help with that?
hi Ellie,
Hi, Jeff.
we're just trying to figure out how to make co-host and everything.
You can click on the person you want, and there should be something that says make co-host. There's usually 3 dots.
Can I make, whoops, more than one person a
Yes.
co-host?
Yep.
So Jeff, should I make you a co-host?
I told Paul that you'd probably make him co-host. And then he could go back and forth and let you know if he sees hands up in the audience for questions and stuff, so.
Hey, Paul, I just made you a co-host.
Great, thank you.
You're welcome.
I'm gonna bring the PowerPoint up then.
Hi, Paul.
Hi, Jeff, how are you?
I'm great, thanks. Start off in about 5 minutes, okay?
Okay,
Thank you.
Hey, Paul, I'm Peter Cook. I'm for the Chilmark Planning Board. Looking forward to this.
how you doing, Peter?
Very good, thank you. Will this all be recorded if,
I got a message when I logged on that we were being recorded.
yeah,
Got it when I logged on.
Hi, yes, it is Hi, being yes, it is recorded. recorded.
Hi, Peter. It's going to be on the Tisbury Zoning Board website when we're all done with the recording.
Great, thank you. Some of my fellow people from the colleagues from the People's Republic of Chilmark couldn't be here, so they wanted to know if they have a chance to catch up with it.
That's great.
So are you seeing the PowerPoint presentation on the screen or no?
Yeah,
Yes, we can see it.
Right, and it's moving as I scroll here?
Yep.
Okay, good. Some reason my screen is not oriented correctly, so I'm not sure what's being seen on the Zoom screen.
If you would like to know, I see Chapter 40B training, fundamentals.
Perfect. That's what it's supposed to say.
Hi, everybody. I'm Jeff Crystal of the Tisbury Zoning Board of Appeals. And I just wanted to welcome Paul with us today. Paul Haverty is a founding partner at Blattman, Bobrowski, Haverty, and Silverstein, and he specializes in municipal law, real estate, and land development. Paul is recognized as one of Massachusetts' leading figures in permitting and litigation involving comprehensive permit projects under Massachusetts General Law, Chapter 40B. In collaboration with the Massachusetts Housing Partnership, which is a public nonprofit organization that is dedicated to increasing affordable housing opportunities in Massachusetts, Mr. Haverty serves as a consultant through the MHP's 40B Technical Review Consultant Program. Utilizing this program, Tisbury was able to obtain his services. That's why he's here today. In this role, he'll be providing assistance to the Tisbury Zoning Board of Appeals on an upcoming permit application and helping Tisbury navigate the complex. A Chapter 40B training session hosted by the Tisbury Zoning Board of Appeals and sponsored by the Massachusetts Housing Partnership. Tonight's presentation is aimed to educate town boards and the public about the comprehensive permitless zoning board website after. So it will be there, everybody, even Chilmark, later on. We might have to charge Chilmark though some money to obtain it. Through the partnership with MHP, Paul Haverty plays a crucial role in Chapter 40B. Tisbury has been through some of those in the last 25 years that I'm aware of. And Paul is extremely valuable too, that we're really looking forward to having. And without further ado, I'd like to have Paul take over, and just thank you very much for doing this.
My pleasure, Mr. Chairman. Thank you. That was a very nice introduction. If anyone's having trouble hearing me, please let me know. I was getting some feedback when the chairman was giving in his opening statements, so I just want to make sure I'm not losing anybody. What I have here is a PowerPoint presentation that I have presented to dozens of boards of appeals and local officials throughout the Commonwealth over the last 10 or so years. The intent of this training today is simply to explain the 40B process generally. It is not intended to respond to specific questions relating to the 40B application that's currently pending before the board. That will all begin to go down tomorrow at the board's hearing. Any specific questions relating to that project, will be a potential cause for an open meeting law violation if we get into them here today, because that's not what's on the board's agenda. So I'm just simply going to go over, sort of these procedural issues for the board to be aware of during the process. I'm happy to answer any questions as they come along. I have found in giving this presentation dozens of times that it's much more enjoyable for everybody if they can just get their questions out when they occur to them. And having that sort of back and forth makes this a lot easier for everybody to get more out of it than if it was just me reading through the slides. So going to the first slide, reviewing the initial application. There are a number of eligibility and submission requirements that an applicant is required to meet before they're allowed to file a comprehensive permit application. And those will be discussed in another slide. There are a number of statutory minima and safe harbors that a municipality can apply. Some of them, so these ones are the statutory minima safe harbors. There's also regulatory safe harbors. So the statutory minimum that everyone is familiar with is the 10% year-round affordable housing. There's also the 1.5% general land area minimum. That is something that has been litigated frequently over the last 5 or 6 years, but very, very rarely has it been successfully litigated. I'm actually aware of one municipality that was able to actually assert a 1.5% total land area safe harbor. And then the third one, I always say this one I've never seen raised in any application ever, and I'm not really sure how to go about applying it if it were raised. And that's the 0.3% of the total land area zoned in a community for residential, commercial, or industrial use, or 10 acres, whichever is larger. I don't fully understand how this works because I've been involved in numerous 40B applications that have been on land area total greater than 10 acres. So it's not a straightforward application as far as that goes. So the regulatory safe harbor provisions is housing production plan safe harbor. So the way that works is if the town has drafted and has approved a housing production plan by EOHLC, and then the town creates affordable housing totaling either 0.5% of your total year-round housing, that will get you a 1-year safe harbor. And if you do 1.0%, you get a 2-year safe harbor. Recent progress towards housing unit minimum, that takes a look at the 12 months prior to the filing of a comprehensive permit application. And if during that time the town has created a total of 2% of its total year-round housing as affordable, then they can assert that safe harbor. And again, that's a 1-year safe harbor. Review of large projects. So there are certain thresholds depending on the number of year-round housing units in the town. It goes from 150 to 200 to 250, all the way up to 300 units would be the maximum threshold for a 40B application that a municipality would have to hear. And then finally, there's a related application safe harbor. And that is sometimes referred to as the cooling off period. And the intent of that safe harbor is to prevent applicants from coming to a board with a general 40A type of development, meeting resistance and then threatening to come forward with a chapter 40B development instead, given the thought process being that they don't really have a desire to construct a 40B project, they just want to use it as a threat. So what this does is if there's any portion of an application that was pending within the 12 months prior to the comprehensive permit application, then the board can assert a safe harbor. And the way the safe harbors work is that an applicant can still file an appeal to the Housing Appeals Committee, even if there is a safe harbor. But if there's been a successfully established safe harbor, Housing Appeals Committee is going to immediately dismiss that appeal and the board will prevail. So this goes back to the submission requirements. So there's different statuses that an applicant can be. They can be a public agency, they can be a nonprofit agency, or they can be a limited dividend organization. I will say I have frequently run into circumstances where a nonprofit agency has also wanted to qualify for status as a limited dividend organization. And that's really having more to do with the inner workings of how they run their operations than it has to do with anything that the board should be concerned with. As long as they are one of these three statuses, then they're okay to move forward with the comprehensive permit application. Second submission requirement is evidence of site control. So that can be a deed, it can be a purchase and sale agreement, an option to purchase, a long-term lease, number of different ways that site control can be established. And then finally, the applicant has to have a project eligibility letter from a qualified subsidizing agency. So there are 4 subsidizing agencies that are authorized to issue project eligibility letters. There's Mass Housing, there's Massachusetts Housing Partnership, there is Mass Development, and then there's the Executive Office of Housing and Livable Communities. So there's some other 40B application submission requirements, preliminary plans versus final plans. So a comprehensive permit application is only required to be based upon preliminary plans. It doesn't have to be final design plans. And the thought process behind that is that an applicant should be able to be aware as to whether or not they're going to be able to get a local approval before they expend the money that goes along with developing final design plans. The application should include existing site conditions and a locus map, preliminary scaled architectural drawings, a tabulation of proposed buildings by type, size, and ground coverage. I don't think that this is really a crucial element of the application, but it's something that is in the regulations. A preliminary subdivision plan, if a subdivision is proposed, a preliminary utilities plan, and a list of requested waivers. So this is important because Chapter 40B gives an applicant the ability to request waivers of any local rules and requirements that it needs waived in order to proceed with the development as they're proposed. So this would not include locally applied state requirements, such as building permit, such as an order of conditions under the Wetlands Protection Act, such as a disposal works permit under Title V. Those are all state permits that are administered locally, and there's no ability to get waivers of those requirements under Chapter 40B. All right, noticing and conducting the required public hearing. So there's a number of different deadlines, some of which are extremely important to make sure that the board complies with, and some are more discretionary rather than mandatory. So distribute application within 7 days of receipt of the application. That is something that is discretionary. It's going to help the board in its process to get that distributed to other boards and local officials as soon as it's able to, but there's no downside to the board if it doesn't do that. If it's, gets those distributed in 14 days, nobody's going to come along and say that it's been constructively approved. Jeff, if you're trying to say something, you're on mute. No, okay. Notice of public hearing. So that has to be done 14 days prior to the opening of the public hearing. And that is a not discretionary. That's something that absolutely has to happen, because the opening of the public hearing has to happen within 30 days of the filing of the application. And failure to open the public hearing within 30 days can result in a constructive approval of the development. The next one is a safe harbor notification. So as I discussed earlier, there are multiple either statutory or regulatory safe harbors. And EOHLC has put provision in its regulations that requires a board to provide written notice to an applicant if it deems any of those safe harbors have been met. And that notification has to come within 15 days of the opening of the public hearing. If the board doesn't provide notice of that safe harbor within those 15 days, then the board loses the ability to raise the safe harbor claim at a later date. If an applicant objects to the assertion of a safe harbor, there's a provision that allows them to go to EOHLC. And EOHLC will then, this says DHCD below here, but it's actually EOHLC now. They changed the name from Department of Housing and Community Development to the Executive Office of Housing and Livable Communities. So the applicant files within 15 days, and then EOHLC has 30 days to file its response. If either party is aggrieved by the EOHLC response, there is a provision that allows for an interlocutory appeal to the Housing Appeals Committee on solely that safe harbor issue. And then once that hearing has completed and Housing Appeals Committee issues its ruling, that can't be appealed until after the matter goes back through a full hearing process, because it's only an interlocutory decision. So once the hearing has been commenced, we've gotten through all of the safe harbor stuff, the board has 180 days to conduct the public hearing and then close the public hearing. Once the public hearing has been closed, the board has 40 days to issue a decision. Now, I want to point something out here. It's a little bit of an arcane issue in the regulations, which is there was a case probably 15 years or so ago that determined that for the 40-day deadline for issuing the decision only means that the board has to vote on the decision within the 40 days. It did not mean that the decision actually had to be filed with the town clerk. Subsequent to that decision, EOHLC revised its regulations to state that once a decision has been rendered, it has to be filed with the town clerk's office within 14 days. So frequently, particularly, if it's been a fairly well-run meeting and the board has had an opportunity to review a draft decision prior to closing the public hearing, you're going to get a decision that comes early in that 40-day period, which is fine, but the board just needs to keep in mind, once it renders its decision, even if there's still 38 days left in that 40-day period, you have 14 days to file the decision with the town clerk's office. So once the board votes on the development, whether to grant, with conditions or to deny, you have 14 days from that vote to file your decision. And if not, potentially could result in a constructive grant. The case law is not clear on that. The regulations are not clear on what the remedy is for failure to file within that 14 days, but I'm aware of 3 separate cases currently pending before the Housing Appeals Committee addressing that exact issue. You wouldn't want to become the 4th. And then once the decision has been filed with the clerk's office, any aggrieved party, which would mean an abutter, or somebody that has standing to file an appeal, may appeal either to Superior Court or to the Land Court. Scheduling a site visit, I'm sure it's probably pretty typical as part of your process to have site visits, particularly on developments that are of a more significant nature, than your standard single-family house. So you want to take care of that early in the process. You want to make sure that you are understanding the site, existing conditions, proposed plan and building design. Probably not something that will be necessary on a smaller type of development, but frequently you would ask applicants to stake out roadways, stake out building locations, and potentially even do balloon tests or something similar of that nature, so the board can get an understanding as to the concept of the heights of the proposed structures. And also you want to be able to take a look at the location of the abutters that are going to be most impacted by the development. Retaining peer review consultants. I always stress to boards, to the extent that they want to do peer review, it is within their right to require an applicant to put money into what's known as a 53G account in order to retain outside consultants to provide expertise to the board that isn't available through any of your local areas. It's very, very important to commence this early in the process. Because again, 180 days goes by a lot quicker than you might think. So the types of peer review that are typical in a 40B would be civil engineering, stormwater, traffic, architecture, and then financial. But financial, it comes with a caveat because the regulations only allow a board to conduct a financial peer review after it has completed all other consultant review and after it's provided the applicant a draft decision that contains all of the proposed conditions and waiver decisions. And if that occurs and the applicant informs the board that the decision would render the project uneconomic, then the applicant can, the board can initiate a pro forma review to confirm whether or not its proposed decision renders the project uneconomic. In my experience, there's not a lot of value to the board to do that type of review. There's some downside in the sense that if you do it and your peer review consultant determines that your decision renders the project uneconomic, you don't really have much of a leg to stand on, with regards to your decision. I always recommend to boards that conditions that you impose should be sustainable irrespective of whether or not they render the project uneconomic. You should be looking at imposing conditions that are necessary to protect the interests that are protected under Chapter 40B, which we'll get into in a little bit. But what you shouldn't be doing is looking to just ladle on conditions that, turn out to be oppressive and aren't really addressing a legitimate interest of local needs. One of the aspects of peer review is that all studies must be prepared on behalf of the applicant. The peer review consultant, they can review studies be prepared on behalf of the applicant. The board cannot retain a peer review consultant to conduct independent studies. And then finally, all written results and reports must be made part of the record. Securing sufficient project information to make an informed decision. Again, you want to focus on the real project issues, impacts early in the review process. Peer review should be commenced as soon as possible, as I mentioned. Request additional information from the applicant. I think that's something that happens in pretty much every 40B application. The applicant, might be coming in with what they believe is all information necessary for a board to make its determination. But in my experience, boards, are very familiar with local issues and concerns and will always ask for more information. Negotiation and work sessions is something that a board is entitled to do. It can be productive. On the other hand, it can also be sometimes controversial. I would not recommend having more than one board member participate in a work session. The real purpose for doing these is really to get the engineers, peer review consultants to have the ability to discuss issues outside of the public hearing in order to eliminate some of the barriers that can occur as a result of the public hearing process on issues that tend to be very technical and complicated. That doesn't mean that the public's not invited to those work sessions. The work sessions would have to be posted and the public would be invited. And in any event, you can't make any decisions as part of a work session, and everything within that work session has to comply with the open meeting law, which means that the next hearing of the board, whatever member participated in the session has to report back the substance of what was discussed at that work session. So balancing regional housing needs versus local concerns. So this is ultimately what the standard is in terms of issuing an approval or a denial under Chapter 40B. The board has to take a look at if there are legitimate issues of local concern relating to health, safety, environmental, design, open space, planning, or other issues of local concern. And even if an issue of local concern, is legitimate and has been raised, it's that alone is not enough. That issue of local concern needs to outweigh the regional need for the affordable housing. So holding deliberation sessions, this is actually not a requirement in the sense that where it says the public hearing is closed, the board is certainly within its rights to draft a decision and discuss it while the public hearing is still open. And the benefit to doing that is it allows you to get feedback both from the applicant and from the public as to the provisions of the draft decision. Once you close the public hearing, it's not appropriate for the board to take any more testimony from either the applicant or the public. So it's really a question of style as to whether the board wants to deliberate after the public hearing is closed or whether it wants to do it when it's open. And it's also a question of time management in terms of whether or not the board reaches the point where they can provide a draft decision while there's still enough time left in the hearing. So once the public hearing is closed, the board deliberates in a logical and orderly fashion, discusses potential conditions, and reviews the requested waivers. And then drafting and issuing the comprehensive permit decision, there's 3 decision alternatives. Denial, which is a risky proposition for a board. The vast majority of denials do get overturned by the Housing Appeals Committee if appealed. Approval as submitted. I literally have never seen that happen once in more than 20 years of doing comprehensive permitting. And then approval with conditions, which is the most common result. So approval with conditions, the conditions should not render the project uneconomic. Again, but my point being, if they do, then they have to be based on a legitimate issue of local need that outweighs the regional need for affordable housing. And again, that ties into this next one, which is conditions and/or requirements must be consistent with local needs. And then the board shall not reduce the number of units for reasons other than evidence of local concern within the board's purview. So that's something that was put into the regulations probably about 15 years ago, to make sure that boards weren't simply saying, we don't like the size of this project, and even though we can't identify a legitimate concern, a legitimate local concern that outweighs the regional need for affordable housing, we're still going to reduce the number of units. If a board does that, an applicant on appeal to the Housing Appeals Committee potentially could claim that they don't even need to show that the board's decision renders the project uneconomic. All they would need to show is that there's no issue of local concern supporting that condition. So appeals of the decision, as I just noted, applicant appeals to the Housing Appeals Committee, and other aggrieved parties appeal to either the Superior Court or the Land Court. Sometimes it happens that the applicant will take an appeal to the Housing Appeals Committee of an approval with conditions, and abutters take an appeal to Superior Court or Land Court of that same decision. When that happens, what will occur is that the appeal brought by the abutters to the Superior Court or Land Court is going to be stayed while the Housing Appeals Committee process is undertaken. Once that process is finished, the appeal that was filed by the abutters is going to be deemed moot. And if the Housing Appeals Committee changes the decision of the board, then appeals can be taken of that decision. Managing the comprehensive permit. So this really indicates that there are things that the board is going to be responsible for after it completes the process and issues the comprehensive permit. So regulatory agreement, deed writers, and monitoring agreement are part of the final approval process with the subsidizing agency, which is the developer's obligation to go through that process. But the regulatory agreement is going to come back to the board for its review and acknowledgement. So you're going to be prepared for that. Lottery and fair housing is part of the final approval process. The applicant is going to be required to prepare an affirmative fair housing marketing plan. That is something that's within the purview of the subsidizing agency, not the board. Again, same with income, asset, and first-time buyer status. That's all part of the final approval process with the subsidizing agency. Lapse of permit. So by default, a comprehensive permit lapses 3 years after the date of the initial grant. The board can impose a longer period of time if it so chooses. I have not run into too many situations where boards have wanted to do that. A permit can be extended. If an applicant comes to the board, 2.5 years before, after the permit is issued, but before it expires, it can get an extension of that permit, and the regulations state that generally speaking, that extension is going to be deemed to be an insubstantial change. Insubstantial change is something that is within the regulations. Anytime a comprehensive permit is granted, an applicant can come back and seek a modification. It's most likely going to occur before the project is constructed. And there are standards for whether or not that modification is a substantial change or an insubstantial change. If the board determines that it's insubstantial, then it's just automatically approved. And if the board makes a determination that it is a substantial change, then a new public hearing is commenced and the board goes through the same process on determining whether or not to approve the modification that's been requested. And the appeal process is the same for that. Transfer of the comprehensive permit is pretty simple. It requires the approval of the subsidizing agency and only requires notification to the board. So the board doesn't have a vote as to whether or not the comprehensive permit can be transferred. And inspections during construction, when we get to the end of the process on the pending application, I will prepare a draft decision that will cover all of those issues in terms of inspections. So that's really the overview of the fundamentals of 40B. Let me see if I can figure out how to stop sharing. Yeah. Okay, I'll share. All right, is everyone still there? Hello? What did I do?
Yep.
We're here.
Oh, you're here. Okay, good. I couldn't see anyone.
We're here, but the screen share is not down yet.
Okay. Trying to figure out how to do that. There we go. Is that good?
No, we're still seeing your share.
Really?
Yeah.
Try that
Oh,
again.
there we go.
Excellent.
Fantastic.
All right, any questions?
Yeah, Paul, I have a couple. This is Rick Homans. The peer review consultants, is that like a stable of professionals who are on call to be able to respond to us, and how how are they selected? Which one in particular the board would request to get involved with this? Then I have one more question after.
Sure. So to answer your first question, it's not so much a stable of consultants. The board would choose who they want to use. I presume there are peer review consultants that are typically used in town, maybe not by the Board of Appeals, but perhaps by the planning board when they review applications. If not, I can certainly recommend somebody. I'll have to figure out who goes over to the island, but happy to do that as well. And again, it's for issues in which the board believes it does not have, the technical expertise to review on its own, and there is not sufficient in-house capability for the town to do it.
And then can you give a couple of examples of situations in other communities where a local issue has outweighed the regional concern over housing? Just to kind of put some color to that issue, which seems to be pretty important.
Sure. So I'll give one issue that I can think of in which a denial was upheld based upon a safety concern. And it had to do with a project that had a very long and winding entrance roadway that had reverse curves and other concerns with no secondary access. And the Housing Appeals Committee issued a decision that upheld the denial of a comprehensive permit based on that. There's other cases in which local planning has been sufficient to uphold a denial of a comprehensive permit. But those are very, very fact specific, and generally require a specific use that a municipality has envisioned for the particular area. There was one, I think in Barnstable, maybe, where it was a marina, sort of a maritime zoning area in which a 40B was proposed. And the town said, you know, we've got a master plan that shows exactly what we want in this area, and this is inconsistent with that master plan. And then the Housing Appeals Committee has a 3-step process in where it looks at the legitimacy of the planning concerns, whether or not those planning concerns included affordable housing, and whether or not that they've been implemented within the town. So it's sort of a, you know, it's a very fact intensive process for that. Okay, Elena Defoe.
Hi there. I work for the Select Board office. So my question was, what is the Select Board office involvement in this? I know we were asked to sign the, I think, eligibility application. So they're in front of the Select Board, I think 2 times, you know, for this project, but we're not going to discuss it. So just what is the general, what are we supposed to do?
So the select board should certainly provide whatever assistance the Board of Appeals needs in the process. So I'm presuming then that this was a LIP, in that the select board, you know, signed off on the LIP application, which it's a different type of process than the typical 40B process. It gives the select board more of a role. But it doesn't really have a role in the Board of Appeals process. It had a role at the beginning in shaping the application, and then in getting the project eligibility letter. It will have a role in the end, because you are now going to be a required signatory of the regulatory agreement with the applicant and EOHLC. But in terms of the process in front of the Board of Appeals, the select board's role is really to provide whatever assistance the Board of Appeals needs.
Thank you.
Connie Alexander?
Hi, yes, Connie Alexander. I'm the chair of the Tisbury Planning Board. And early on in your slide presentation, you mentioned something about state permits. And I couldn't get down, what kind of state permits might there be on a project that you said would have to apply, even though sometimes they can get waivers for local permitting?
Right.
Couldn't get it from
So-
the state. Could you give me an example of what type of state permit that might look like?
Yeah, so I did initially. There are certain state permits that are administered locally, right? So
Right.
when a building permit is issued, that's not considered to be a local permit. That's a state permit under the state building code. When the Conservation Commission issues an order of conditions, it's issuing a state permit, but it's administering it locally. Whereas if the Conservation Commission has a local wetlands bylaw that is over and above the protections offered under the Wetlands Protection Act, that's a local bylaw, it's a local permit, and the Board of Appeals now becomes the entity that issues that permit. But the Conservation Commission is still the entity that issues the order of conditions. And again, similar with septic approval under Title V, Board of Health retains all jurisdiction to issue a Title V permit, but it doesn't have jurisdiction under any local rules that are more stringent than Title V. That permit would be issued by the Board of Appeals.
Okay. And then you also mentioned that once they receive the application, it should be distributed amongst other town boards within 7 days. But you said
Yes.
that there's no downside to that.
Correct. That's really just a timing issue. So that's to make sure that all other boards are presented with this information and have the opportunity to weigh in and give advice to the Board of Appeals during its hearing process. And obviously, the sooner they get that material, the more time they have to prepare something and submit it.
And
But
what constitutes distribution? Is it posting on a website or is it actual sending of documents? to a-
I don't think that there's any precedent as to what constitutes notice. It could be email, with the attachments. It could be just a notification that, the application is now up on our website. Please review and
Okay,
provide whatever comments you may have.
okay. And then you, later on in the presentation, you repeated the phrase a subsidizing agency. What would be an example of a subsidizing agency?
So there are 4 subsidizing agencies currently authorized to grant project eligibility letters in Massachusetts. And that's Mass Housing Partnership, Mass Development, and the Executive Office of Housing and Livable Communities. They all have multiple different funding programs under their umbrellas, but those
Got
are the
it.
4 subsidizing agencies.
I understand now. Okay, that makes sense. And then you mentioned there can be extensions. Is there a limit on how many extensions?
No.
Nope. Okay, that's it. Those are my questions. Thank you very much.
Okay, and I did want to clarify in terms of extensions, there are a number of deadlines within the regulations, and pretty much all of those can be extended through agreement of the parties. It's not at all uncommon, particularly, on significant developments that require, a great deal of review, for the applicant to agree to extend that 180-day deadline. I've had them go, upwards of a year of permitting, before the public hearing closed. But it has to be, at the agreement of the applicant. So the board can't impose a time frame longer than the 180 days. All it can do is ask the applicant whether they're willing to grant an extension.
Okay, thank you so much.
You're welcome. Jeff?
Sure, thanks. So 2 questions really. With the Martha's Vineyard Commission usually reviewing either as a mandatory referral to them for the 40B, the tolling for Tisbury would stop, correct?
I'm not clear on that. I mean, I think that if this is a mandatory filing, it probably should have come before they filed with your board. But I understand that there was, some confusion as to that status. What I would request is for the applicant to agree to toll the time while they're in front of the Martha's Vineyard Commission, only
Okay.
because I wouldn't want the board to be put in a position where it's unsure whether or not, by its terms it was tolled. I know that the MVC regulations state that it will be tolled. I just don't know whether or not, that would be superseded by 40B or not. And I wouldn't want to take the risk. So I would prefer to get, an agreement from the applicant if that has to happen.
Understood. And my other question, back to Elena Defoe's question. When the application is stamped by the town clerk, would it already have been in front of the select board for their review? Go to the town clerk first and then goes simultaneously?
So the select board wouldn't review the comprehensive permit application. What they would have reviewed would have been the project eligibility application. And because that allows them, well, first of all, in this instance, if it's a LIP, they have to sign off. Otherwise, they don't go forward with the eligibility process. But just generally speaking, the select board is required to be given a copy of the application. They review it, they provide comments to the subsidizing agency. Subsidizing agency takes those comments, incorporates them into their project eligibility letter. That is what then allows the applicant to move forward and file their comprehensive permit application with the Board of Appeals. The comprehensive permit application is not required to be reviewed by any board other than the Board of Appeals. Laura?
Thank you so much for this great presentation, Paul. I'm Laura Silber. I'm the Island Housing Planner for the Martha's Vineyard Commission, and we're about to take up the update for the housing production plans for the 6 towns. And I've recently gotten some questions from various boards in the town of Tisbury as to what the importance is of the town having an HPP on file with EOHLC. Some questions about the town's responsibility for keeping their subsidized housing inventory updated, which I know has been an issue for several of the island towns in the past, and what the intersection of having an approved and certified HPP on file with EOHLC is with 40B. So if you could just elaborate a little bit on that, I think it would really
Sure.
assist the conversation. Thank you.
Yeah, so I addressed this in the safe harbor discussion. If the town has an approved housing production plan, the thresholds for achieving safe harbor are lower. If you have an approved housing production plan and you approve 0.5% of your year-round housing within a 1-year period, you get a 1-year safe harbor. If you approve a total of 1%, you get a 2-year safe harbor. If you don't have a housing production plan, you're completely ineligible for that safe harbor, and you would then have to rely upon the 2% recent progress safe harbor, which is either double or 4 times the amount of units required in order to qualify for that safe harbor. So there's clearly a substantial benefit to the municipality in having a housing production plan. I do know I can't really speak too much to the question about the maintaining of the subsidized housing inventory in the communities, other than to say, I mean, I recognize EOHLC's, the entity that maintains the subsidized housing inventory. If they're not provided information regarding the creation of units, they're not going to know about them, and you're not going to get them added to your subsidized housing inventory. So it's certainly very, very beneficial to provide notice as soon as a unit is created so that they can get added to your subsidized housing inventory. Anything
Thank you.
else? Did I miss any?
No, thank you. Just the I was wondering if you have thoughts on, I know there are other communities that are in safe harbor that are actually still utilizing 40B and
So-
utilizing their safe harbor to leverage more year-round units in a 40B, like Nantucket and Provincetown. And I'm wondering if you could speak to like the advantages of using 40B when you're in safe harbor and how that's a tool for the
Right.
towns.
So what I will tell you is that I represented a board as MHP consultant, probably started 6 or 7 years ago, and they were very low. They were around like 2 or 3%. And they got into a safe harbor and then just kept soliciting affordable housing developments. And they went, I think, over a period of 4 years, approved 40B after 40B after 40B while holding control, because they had the right to deny any of the applications. So they were, had a very significant role in shaping the applications that came before them. And they went from like 2 or 3% to 10%, and are now, in an extended safe harbor. So, I mean, I think that there's a great advantage to a municipality to utilize the housing production plan in that manner. And I think that's the purpose. That's why the housing production plan safe harbor was adopted by EOHLC, is to encourage municipalities to take advantage of it, allow it to be used in a manner in which affordable housing is created in a way that is palatable to the town, rather than having, the proverbial gun to your head. You're actually going to be the one that's controlling what gets developed, and it, it can be very successful. We did a very similar thing in my own hometown in Chelmsford. I was town council there for 7 years, but before that, I was a local volunteer, and I was on the housing production plan committee. We drafted a housing production plan, and again went from like 4% to 10%. So it can be a very useful tool. Connie.
Thanks. On that topic, the housing production plan, once you create one and it's accepted, does it expire and do you need to renew it?
Good for 5 years.
5 years. That's a good answer. Thank you. And then will your slideshow be available to us? Will it be,
I think it's already been posted on the website.
great. Okay, I didn't see it, but thanks for that. Thank you very much.
Welcome. Tony?
Yes, sir. Excuse me if this is redundant. I had to step away for a few minutes. And when I came back, you were explaining the difference between statutory regulations and local regulations and how they apply. You had mentioned the Martha's Vineyard Commission. If you've already addressed where they fall, where their regulations fall in that category, I missed it.
So that's an interesting question. I'm aware of land court case law that determined that Martha's Vineyard Commission is not considered to be a local board, and therefore their provisions are not waivable under Chapter 40B. I've seen others take the opposite approach, and obviously trial court decisions are not precedent. But if I had to take a guess, I would think that that's probably the side that it would come down on.
Okay, the reason I ask is, as you may know, as you probably know, the Martha's Vineyard Commission regulations are incorporated in the local regulations. Sometimes, if the local jurisdiction does not adopt the regulations themselves, the Martha's Vineyard Commission can promulgate the regulations for the local community, but they wind up within the local regulation publications. There are a number of those conditions within the zoning bylaw, and within the health code, there are also some which are the result of regulations for districts of critical planning concern. So that's I guess that's the distinction I'm concerned about, I guess.
Okay, I mean, without knowing specifics, I can't really offer an opinion as to whether, one particular regulation constitutes a local regulation or whether it's something within the Martha's Vineyard Commission's jurisdiction. I would say that if a project goes through the Martha's Vineyard Commission and gets whatever approval is required, I think that that would be sufficient. And anything that's been locally adopted, even through the auspices of the Martha's Vineyard Commission, would probably be waivable.
Okay, that doesn't seem appropriate, but I don't argue with you, of course, because I don't know.
All right, any other questions? Guess we're all set.
Pam, no questions, Pam? I saw you had your hand up earlier.
Nope, I did not have my hand up.
Well,
I think I
No,
would just,
I did,
Oh,
sorry. Yeah, I was trying to be 100% sure. I mean, I know what Laura's saying, which I think is a great idea. We do need that, but for a list, if we didn't have the MVC doing the the is it HPP? Housing Protection, yeah, HPP.
Yes.
Would that normally fall within the select board office? I'm trying to remember. In the past, I've remembered, if it was, the previous town administrator putting in the inventory. And I just wanted to make sure, if that weren't in place, is it the select board office?
In my
Or
experience, it's been planning board and select board.
Okay.
Each sign off.
Okay.
And then it's, it's a submittal to EOHLC for their approval.
Okay. Okay, great. Thank you.
And I think we also had the Affordable Housing Committee, Victor's on, so he might be able to weigh in on, but I'm pretty sure we had also the Affordable Housing Committee in conjunction with the Select Board review the numbers and get it together.
We were involved in the most recent one. The one 5 years ago that's just expired was really before my time on the Affordable Housing Committee. So I'm not certain about the initiation of it, but I think that what Laura spoke about, we need to get our act together to be able to participate in what the commission is offering to the towns on the island to get a new plan done. So actually, the Affordable Housing Committee is meeting tomorrow. It's going to be an item on our agenda to support getting that done.
Oh, that's great.
Hey, Drew?
Hi, I'm the health agent for the town of Tisbury. I'm wondering, so for departments that have waiver requests in them, but are there any particular steps that we need to take or any actions that we need to coordinate with the ZBA, or just kind of looking for general guidance on how to handle the waiver request from your department?
So I think would be very helpful to the board if your board would provide suggestions and feedback as it relates to those waiver requests. If there are concerns about granting those waivers, then, your board should raise exactly what those concerns are. Recognizing, that, again, this is subject to a standard that is whether or not there's a legitimate health, safety, or other issue of local concern that outweighs the regional need for affordable housing. So the fact that it's just because it's contrary to one of your local rules doesn't mean that the board has the authority to deny the waiver. What you're going to need to do is actually show why that waiver is necessary to protect a specific issue of local concern.
Okay, thank you.
Welcome.
Anybody else with
Anyone
any
else?
questions? All right, seeing none. Paul, thank you very much for tonight. Very informative. And I know we have stated a couple of times the slides are on the website, and also the video will be posted as well, this meeting. Thank you very much.
Great. Thanks, everyone. Have a good night. I'll see at least some of you tomorrow.
See you soon. Take care.
All right, bye.
Thank you.
Bye.